Members of the jury, I would like to thank you for your attention during the trial. Please pay attention to the instructions I'm about to give you. You will also receive a copy of these instructions in writing. In this case, Caylee Marie Anthony is accused of murder in the first degree, aggravated child abuse, aggravated manslaughter of a child, and 4 counts of providing false information to a law enforcement officer. Murder in the first degree includes the lesser crimes of murder in the second degree, manslaughter, and third-degree felony murder, all of which are unlawful. A killing that is excusable or was committed by the use of justifiable deadly force is lawful. If you find Caylee Marie Anthony was killed by Caylee Marie Anthony, you will then consider the circumstances surrounding the killing and deciding if the killing was murder in the first degree, or was murder in the second degree, or manslaughter, or third-degree felony murder, or whether the killing was excusable or resulted from justifiable use of deadly force. The killing of a human being is justifiable homicide and lawful if necessarily done while resisting an attempt to murder or commit a felony upon the defendant, or to commit a felony in any dwelling house in which the defendant was at the time of the killing. The killing of a human being is excusable and therefore lawful under any one of the following 3 circumstances. 1, when the killing is committed by accident and misfortune, in doing any lawful act by lawful means with usual ordinary caution and without any unlawful intent, or 2, when the killing occurs by accident and misfortune in the heat of passion, upon any sudden and sufficient provocation, or 3, when the killing is committed by accident and misfortune resulting from a sudden combat, if a dangerous weapon is not used and the killing is not done in a cruel and unusual manner. I now instruct you on the circumstances that must be proved before Caylee Marie Anthony may be found guilty of murder in the first degree, aggravated child abuse, aggravated manslaughter of a child, and 4 counts of providing false information to a law enforcement officer or any lesser included crime. Murder in the first degree. There are 2 ways in which a person may be convicted of first-degree murder. One is known as premeditated murder, and the other is known as felony murder. In order to find the defendant guilty of murder in the first degree, the state must convince you beyond a reasonable doubt of the defendant's guilt of either premeditated murder or felony murder. While you must all agree that the state has proven first-degree murder beyond a reasonable doubt, you need not be unanimous in your opinion as to whether that finding is based upon premeditated murder or felony murder, as I shall now define those terms. To prove the crime of first-degree premeditated murder, the state must prove the following 3 elements beyond a reasonable doubt. 1, Caylee Marie Anthony is dead. 2, the death was caused by the criminal act of Caylee Marie Anthony. 3, there was a premeditated killing of Caylee Marie Anthony. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. Killing with premeditation is killing after consciously deciding to do so. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. The question of premeditation is a question of fact to be determined by you from the evidence. It would be sufficient proof of premeditation if the circumstances of the killing and the conduct of the accused convince you beyond a reasonable doubt of the existence of the premeditation at the time of the killing. First-degree felony murder. To prove the crime of first-degree felony murder, the state must prove the following three elements beyond a reasonable doubt. 1. Caylee Marie Anthony is dead. 2. The death occurred as a consequence of and while Caylee Marie Anthony was engaged in the commission of aggravated child abuse, or the death occurred as a consequence of and while Caylee Marie Anthony was attempting to commit aggravated child abuse. 3. Caylee Marie Anthony was the person who actually killed Caylee Marie Anthony. In order to convict of first-degree felony murder, it is not necessary for the state to prove that the defendant had a premeditated design or intent to kill. To prove the crime of aggravated child abuse, the state must prove the following two elements beyond a reasonable doubt. 1. Caylee Marie Anthony knowingly and willfully committed child abuse upon Caylee Marie Anthony, and in doing so caused great bodily harm, permanent disability, or permanent disfigurement. 2. Caylee Marie Anthony was under the age of 18 years. Willfully means intentionally, knowingly, and purposely. Child abuse means the intentional infliction of physical or mental injury upon a child, or an intentional act that could reasonably be expected to result in physical or mental injury to a child, or active encouragement of any person to commit an act that results or could reasonably be expected to result in physical or mental injury to a child. Aggravated manslaughter of a child. To prove the crime of aggravated manslaughter of a child, the state must prove the following two elements beyond a reasonable doubt. 1. Caylee Marie Anthony is dead. 2. Caylee Marie Anthony's acts caused the death of Caylee Marie Anthony, or the death of Caylee Marie Anthony was caused by the culpable negligence of Caylee Marie Anthony. I will now define culpable negligence for you. Each of us has a duty to act reasonably towards others. If there is a violation of that duty without any conscious intent to harm, that violation is negligence. But culpable negligence is more than a failure to use ordinary care towards others. In order for negligence to be culpable, it must be gross and flagrant. Culpable negligence is a course of conduct showing reckless disregard of human life or of the safety of persons exposed to its dangerous effects, or such an entire want of care as to raise a presumption of a conscious indifference to the consequences, or which shows a wantonness or recklessness or grossly careless disregard of the safety and welfare of the public, or such an indifference to the rights of others as is equivalent to an intentional violation of such rights. The negligent act or omission must have been committed with other disregard for the safety of others. Culpable negligence is consciously doing an act or following a course of conduct that the defendant must have known or reasonably should have known was likely to cause death or great bodily harm. If you find the defendant guilty of aggravated manslaughter of a child, you must then determine whether the state has further proved beyond a reasonable doubt that Caylee Marie Anthony was a child whose death was caused by the neglect of Caylee Marie Anthony, a caregiver. Child means any person under the age of 18 years. Caregiver means a parent, adult household member, or other person responsible for a child's welfare. Neglect of a child means a caregiver's failure or omission to provide a child with care, supervision, and services necessary to maintain a child's physical and mental health, including but not limited to food, nutrition, clothing, shelter, supervision, medicine, and medical services that a prudent person would consider essential for the well-being of the child. Repeated conduct or a single incident or omission by a caregiver that results in or could reasonably be expected to result in a substantial risk of death of a child may be considered in determining neglect. False information to a law enforcement officer. To prove the crime of false information to a law enforcement officer, the state must prove the following 5 elements beyond a reasonable doubt. 1. Uri Melich was conducting a missing persons investigation. 2. Uri Melich was a law enforcement officer. 3. Caylee Marie Anthony knew that Uri Melich was a law enforcement officer. 4. Caylee Marie Anthony knowingly and willfully gave false information to Uri Melich. 5. Caylee Marie Anthony intended to mislead Uri Melich or impede the investigation. Willfully means intentionally, knowingly, and purposefully. In considering the evidence, you should consider the possibility that although the evidence may not convince you that the defendant committed the main crimes of which she is accused, there may be evidence that she committed other acts that would constitute a lesser included crime. Therefore, if you decide that the main accusation has not been proved beyond a reasonable doubt, you will next need to decide if the defendant is guilty of any lesser included crime. The lesser crimes indicated in the definition of first-degree murder or second-degree murder, manslaughter, or third-degree murder. The lesser crime indicated in the definition of aggravated child abuse is child abuse. Second-degree murder. To prove the crime of second-degree murder, the state must prove the following three elements beyond a reasonable doubt. 1. Caylee Marie Anthony is dead. 2. The death was caused by the criminal act of Caylee Marie Anthony. 3. There was an unlawful killing of Caylee Marie Anthony by an act eminently dangerous to another and demonstrating a depraved mind without regard for human life. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. An act is eminently dangerous to another and demonstrating a depraved mind if it is an act or series of acts that 1. A person of ordinary judgment should know is reasonably certain to kill or do serious bodily injury to another, and 2. Is done from ill will, hatred, spite, or an evil intent, and 3. Is of such a nature that the act itself indicates an indifference to human life. In order to convict of the crime of second-degree murder, it is not necessary for the state to prove the defendant had an intent to cause death. Manslaughter. To prove the crime of manslaughter, the state must prove the following two elements beyond a reasonable doubt. 1. Caylee Marie Anthony is dead. 2. Caylee Marie Anthony's act or acts caused the death of Caylee Marie Anthony, or the death of Caylee Marie Anthony was caused by the culpable negligence of Caylee Marie Anthony. However, the defendant cannot be guilty of manslaughter if the killing was either justifiable or excusable homicide. The killing of a human being is justifiable homicide and lawful if necessarily done while resisting an attempt to murder or commit a felony upon the defendant, or to commit a felony in any dwelling house in which the defendant was at the time of the killing. The killing of a human being is excusable and therefore lawful under any one of the following three circumstances. 1, when the killing is committed by accident or misfortune, in doing any lawful act by lawful means with usual ordinary caution and without any unlawful intent, or 2, when the killing occurred by accident and misfortune in the heat of passion upon any sudden and sufficient provocation, or 3, when the killing is committed by accident or misfortune resulting from sudden combat if a dangerous weapon is not used and the killing is not done in a cruel and unusual manner. In order to convict of manslaughter by act, it is not necessary for the state to prove the defendant had an intent to cause death, only in the intent to commit an act that was not justified or excusable or which caused death. I will now define culpable negligence for you. Each of us has a duty to act reasonably towards others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. But culpable negligence is more than a failure to use ordinary care towards others. In order for negligence to be culpable, it must be gross and flagrant. Culpable negligence is a course of conduct showing reckless disregard of human life or of the safety of persons exposed to its dangerous effects, or such an entire want of care as to raise a presumption of a conscious indifference to to the consequences or which shows wantonness or recklessness or a gross careless disregard of the safety and welfare of the public, or such an indifference to the rights of others as equivalent to an intentional violation of such rights. The negligent act or omission must have been committed with utter disregard for the safety of others. Culpable negligence is consciously doing an act or following a course of conduct that the defendant must have known or reasonably should have known was likely to cause death or great bodily injury. To prove the crime of third-degree felony murder, the state must prove the following three elements beyond a reasonable doubt. Caylee Marie Anthony is dead. 2, the death occurred as a consequence of and while Caylee Marie Anthony was engaged in the commission of child abuse, or the death occurred as a consequence of and while Caylee Marie Anthony was attempting to commit child abuse. 3, Caylee Marie Anthony was the person who actually killed Caylee Marie Anthony. It is not necessary for the state to prove the killing was perpetrated with a design to effect death. Child abuse means the intentional infliction of physical or mental injury upon a child, or an emotional or an intentional act that could reasonably be expected to result in physical or mental injury to a child when the person knowingly or willfully abuses a child without causing great bodily harm, permanent disability, or permanent disfigurement to a child. Willfully means intentionally, knowingly, and purposely. In order to prove that the defendant attempted to commit the crime of child abuse, the state must prove the following beyond a reasonable doubt. 1, Caylee Marie Anthony did some act towards committing the crime of child abuse that went beyond just thinking or talking about it. 2, she would have committed the crime except that someone prevented her from committing the crime of child abuse or she failed. It is not an attempt to commit child abuse if the defendant abandoned her attempt to commit the offense or otherwise prevented its commission under circumstances indicating a complete and voluntary renunciation of her criminal purpose. Child abuse. To prove the crime of child abuse, the state must prove the following two elements beyond a reasonable doubt. 1, Caylee Marie Anthony intentionally inflicted physical or mental injury upon Caylee Marie Anthony or committed an intentional act that could reasonably be expected to result in physical or mental injury to Caylee Marie Anthony. 2, the victim was under the age of 18 years. The defendant has entered a plea of not guilty. This means you must presume or believe the defendant is innocent. The presumption stays with the defendant as to each material allegation in the indictment through each stage of the trial, unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed, and the defendant is the person who committed the crime. The defendant is not required to present evidence or to prove anything. Whenever the words reasonable doubt are used, you must consider the following. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if, after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if, having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced in this trial and to it alone that you are to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in the evidence, or lack of evidence. If you have a reasonable doubt, you should find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are: did the witness seem to have an opportunity to see and know the things about which the witness testified? Did the witness seem to have an accurate memory? Was the witness honest and straightforward in answering the attorney's questions? Did the witness have some interest in how the case should be decided? Does the witness's testimony agree with the other testimony and other evidence in the case? Has the witness been offered or received any money, preferred treatment, or other benefit in order to get the witness to testify? Has any pressure or threat been used against the witness that affected the truth of the witness's testimony? Did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? You may rely upon your own conclusions about the witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. When evidence concerning canine searches, it is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than others. Some things you should consider in evaluating canine searches are: 1, the canine's training and certification records, including an explanation of the meaning of the particular training and certification. 2, the field performance records, including any unverified alerts. 3, the experience and training of the officer handling the canine, as well as any other objective evidence known to the officer about the canine's reliability. You may rely upon your own conclusions about this type of evidence. A juror may believe or disbelieve all or any part of the evidence or the testimony. Expert witnesses are like other witnesses with one exception. The law permits an expert witness to give his or her opinion. However, an expert's opinion is only reliable when given on a subject about which you believe he or she to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. The Constitution requires the state to prove its accusations against the defendant. It is not necessary for the defendant to disprove anything, nor is the defendant required to prove her innocence. It is up to the state to prove the defendant's guilt by evidence. The defendant exercised a fundamental right by choosing not to be a witness in this case. You must not view this as an admission of guilt or be influenced in any way by her decision. No juror should ever be concerned that the defendant did or did not take the witness stand to give testimony in the case. Statements claimed to have been made by the defendant outside of court have been placed before you. Such a statement should always be considered with caution and be weighed with great care to make certain it was freely and voluntarily made. Therefore, you must determine from the evidence that the defendant's alleged statements were knowingly, voluntarily, and freely made. In making this determination, you should consider the total circumstances, including but not limited to: 1, whether when the defendant made the statement, she had been threatened in order to get her to make it, and 2, whether anyone had promised her anything in order to get her to make it. If you conclude that the defendant's out-of-court statement was not freely and voluntarily made, you should disregard it. These are some general rules that apply to your discussions. You must follow these rules in order to return a lawful verdict. You must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are dependent upon you to make a wise and legal decision in this matter. This case must be decided only upon the evidence that you had heard from the testimony of witnesses and have seen in the forms of exhibits and evidence in these instructions. This case must not be decided for or against anyone because you feel sorry for anyone or angry at anyone. Remember, the lawyers are not on trial. Your feelings about them should not influence your decision in this case. Your duty is to determine if the defendant has been proven guilty or not in accord with the law. Whatever verdict you render must be unanimous. That is, each juror must agree to the same verdict. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about his or her testimony. Your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and on the law contained in these instructions. Deciding a verdict is exclusively your job. I cannot participate in that decision in any way. Please disregard anything I may have said or done that makes you think I prefer one verdict over another. You may find the defendant guilty as charged in the indictment or guilty of such lesser included crimes as the evidence may justify, or not guilty. If you return a verdict of guilty, it should be for the highest offense which has been proven beyond a reasonable doubt. If you find no offense has been proved beyond a reasonable doubt, then of course your verdict must be not guilty. Only one verdict may be returned as to each crime charge. This verdict must be unanimous. That is, all of you must agree to the same verdict. The verdict must be in writing, and for your convenience, the necessary forms of verdicts have been prepared for you. They are as follows. Verdict as to count 1, first-degree murder. We, the jury, find the defendant guilty of first-degree murder as charged in the indictment. We, the jury, find the defendant guilty of the lesser-included offense of second-degree murder. We, the jury, find the defendant guilty of the lesser-included offense of manslaughter. We, the jury, find the defendant guilty of the lesser-included offense of third-degree felony murder. We, the jury, find the defendant not guilty. So say we all, dated at Orlando, Orange County, Florida, on this blank date of July. When you have arrived at a decision, your foreperson will execute the verdict form by checking the space adjacent to the statement that reflects your verdict date and sign the verdict form. Verdict as to count 2, aggravated child abuse. We, the jury, find the defendant guilty of aggravated child abuse as charged in the indictment. We, the jury, find the defendant guilty of the lesser-included offense of child abuse. We, the jury, find the defendant not guilty. So say we all, dated at Orlando, Orange County, Florida. Verdict as to count 3, aggravated manslaughter of a child. We, the jury, find the defendant guilty of aggravated manslaughter of a child as charged in the indictment. We, the jury, find the defendant guilty of the lesser-included offense of manslaughter. We, the jury, find the defendant not guilty. So say we all. Following that, there is some special findings as to count 3. Special finding. We, the jury, find that Caylee Marie Anthony was a caregiver for Caylee Marie Anthony at the time of the offense. We, the jury, find that Caylee Marie Anthony was not a caregiver for Caylee Marie Anthony at the time of the offense. So say we all, dated Orlando, Orange County, Florida. Special finding number 2 as to count 3. We, the jury, find that Caylee Marie Anthony was under the age of 18 years of age at the time of the offense. We, the jury, find that Caylee Marie Anthony was not under 18 years of age at the time of the offense. So say we all, dated at Orlando, Orange County, Florida. Verdict as to counts 4, 5, and 6. We, the jury, find the defendant guilty of providing false information to a law enforcement officer as charged in the indictment. We, the jury, find the defendant not guilty. That's 4, 5, 6, and 7. A separate crime is charged in each count of the indictment, and while they have been tried together, each crime and the evidence applicable to it must be considered separately in a separate verdict returned as to each. A finding of guilty or not guilty as to one crime must not affect your verdict as to the other crime charged. In just a few moments, you will be taken to the jury room by the court deputy. The first thing you should do is elect a foreperson. The foreperson presides over your deliberations like a chairman of a meeting. It is the foreperson's job to sign and date the verdict form when all of you have agreed on a verdict in this case. The foreperson will bring the verdict form back to the courtroom when you return. A verdict finding the defendant either guilty or not guilty must be unanimous. The verdict must be the verdict of each juror as well as the jury as a whole. During deliberations, jurors must communicate about the case only with one another, and only when all jurors are present in the jury room. You are not to communicate with any person outside the jury about this case. Until you have reached a verdict, you must not talk about this case in person or through the telephone, writing, or electronic communications such as a blog, Twitter, email, text message, or any other means. Do not contact anyone to assist in your deliberations. These communication rules apply until I discharge you at the end of the case. If you become aware of any violation of these instructions or any other instructions I have given in this case, you must tell me by giving a note to the court deputy. In closing, let me remind you that it is important that you follow the laws spelled out in these instructions in deciding your verdict. There are no other laws that apply to this case. Even if you do not like the laws, you must use them. Correction, even if you do not like the laws that must be applied, you must use them. For 2 centuries, we have agreed to a constitution and to live by the law. No juror has the right to violate rules we all share. Ladies and gentlemen of the jury, as you proceed to retire and begin your deliberations, 5 of your number will separate from you at this time. That will be done back in the jury room, and they will be taken to a separate area where I will give them some additional instructions. Members of the jury, you may retire now to begin your deliberations.